they seem to have lost faith in that.
Well, I don't want to join issue with the leader of the opposition, because that's not the ambit of what we are here to speak. But what I want to say is this, that people should not presume that the judiciary should be performing the role of the opposition in parliament or the state legislatures. Too often there's a misconception that the judiciary has to play the role of the opposition in legislatures, which is not so. We are here to scrutinize laws. We are entrusted with the duty to scrutinize executive action on whether it is consistent with the law, whether it is consistent with the constitution. There's a different space in a democracy for the political opposition. And what people try to do is to use the judiciary and to shoot from the shoulders of the judiciary and to try and convert the court into a space for the political opposition. That is not the role of the
court. So the Maharashtra
court.
elections have just taken place, and the UBT Sena, they seem to say that history, and they have said this several times since, that history will not forgive Justice Chandrachud for the delay in giving the judgment and allowing the hijack of the party that it happened. It's the decision that was taken. He allowed, because of his judgment, this unfairness of people breaking away from the party, forming another government, and then so in delay and the judgment that you gave.
Well, my answer is very simple. You point out to us that we are not working even for a minute of the time that we are assigned to do our work, and such a criticism would be valid. Throughout this year, we were dealing with seminal constitutional cases, 9 judge bench decisions, 7 judge bench decisions, 5 judge bench decisions. Now, should any one party or individual decide what case the Supreme Court should hear? Sorry, that choice is for the Chief Justice. That these are, if you don't take up old cases, you are told, well, cases are languishing before the Supreme Court for 20 years. Important constitutional cases are pending before the Supreme Court for 20 years. Why is the Supreme Court not taking up these 20-year-old cases and dealing with some recent case? And then if you take up old cases, then you are told that, well, but you didn't take up this particular case. Well, you have limited manpower, and you have a given complement of judges. You have to draw the balance ultimately.
I don't want to take up cudgels on behalf of any political party, but like what the UBT says is that, I mean, it is one of our largest states. It is the richest state in the country. This is where the financial capital is located, and political instability to a large extent. And they just keep saying they lost the election, yes, but they feel that that it broke the back of a major political party, the delay in your decision.
You see, this is the problem. The real problem is this, that a given segment of the polity feels that, well, you are independent if you follow my agenda.
Yeah.
That, you pursue my agenda, which is inclusive of cases which I think you should be deciding. We decided electoral bonds. Was that any less important?
Yeah.
It was a matter which dealt with the foundational structure.
Are you happy with that decision?
I'll come back to that in a moment.
Yeah.
We decided electoral bonds. That's one. We decided recently the Aligarh Muslim University case, the closure of the madrasas under an order of the Allahabad High Court. We have dealt with issues pertaining to the disability rights of individuals. Okay. Is disability in any way less significant than any of these cases that we are referring to? We have decided critical issues pertaining to the federal structure. This year, and these are all cases which we have decided this year, we decided the constitutional validity of Section 6A of the Citizenship Act, which gave citizenship to certain people who had migrated from Bangladesh prior to 25th of March, not CA, who had migrated prior to 25th of March 1971.
Okay.
Was that less significant? We dealt with a case on whether, a constitution bench case on whether lakhs and lakhs of individuals belonging to not the highest strata of society, but the lower strata of society. The question was whether a person who has a license to drive a light motor vehicle can drive a transport vehicle below 7,500 kgs. Now, that would have affected the livelihoods of lakhs of people. We delivered judgment on that just before my term came to an end. Are these cases that we have decided? In fact, we decided 38 Constitution bench references during my tenure, including this year itself. Are these cases any less significant than a particular case which we didn't decide or we couldn't decide?
Article 370, that also was
yes.
yeah.
Yes, that's right. That we decided last year. But I'm talking of the cases we decided this very year. Now, the cases which we decided this year, any of these cases which I have referred to earlier, are these cases less significant? Or do we then follow an agenda which others set for us that, well, you have to decide this case for me today. If you don't decide my case, then, well, you're not independent. This is something which is unacceptable. And the real problem today is this, and that's why, I must say this. It's because we have refused during my tenure as a Chief Justice. We have refused to be dictated by any third party on which cases to decide. Sometimes, very highly resourced persons come to the court and they try and suborn the system by saying, well, my case should be heard first. And this was a matter of concern to me as Chief Justice. Should we be listening to those cases only because the most resourced in terms of lawyers, in terms of the clients whom they represent, come to court and say, well, hear my case first? Sorry, we are not going to give that priority to people who are merely because they have resource and they have the ability to afford the best in terms of legal representation. When you sort of take cudgels for the system, for the ordinary Indian, and say this is not going to be how the court will work, obviously there's going to be a backlash.
Is there political pressure on the Supreme Court to take up certain cases by the ruling party?
No. In fact, you
didn't come under any pressure.
I don't think there was any pressure at all on what cases we should take up. In fact,
on Article 370, on Ayodhya, on Sabrimala, all these very, very important cases.
Look, Article 370 was pending before the Supreme Court for long, right? So if there was pressure, why did the Supreme Court wait for taking such a decision on that case? I mean, the decision came in 2019. The case was heard much, much later, several years later. And there's never the order in which cases are to be heard is decided by the Supreme Court and by the Chief Justice of India. There is no political pressure on which cases should be heard and which cases should be prioritized. That's entirely a matter for the judiciary to take up.
Was the process and the procedure appropriate on Article 370, the way it was done? Because there's a lot of criticism on that too.
Smita,
you don't want to go into individual?
I wouldn't know, for the reason that what we decided is up there.
Okay.
I'm not here either to defend my judgment or to critique the judgment. That's for others to do.
Does it bother you when you read the critique and you say, do you rethink and say that maybe did I do right, did I do wrong? Does that happen?
We've laid down the law, and once we've laid down the law, qua us, that is the law which we have laid down. And I know that, in any case that you decide after careful reflection, after considering rival arguments, and you take a decision which at that point of time when you decide is the correct decision. Now, future generations, in several cases, revisit judgments. For instance, I revisited the judgment
of your father.
Of my father in ADM Jabalpur, for instance, and we said that the judgment was wrong. Or their judgment, on adultery, and we said that, well, the judgment of our Supreme Court, of our court on adultery was wrong. That's the churning process which takes place.
So when you revisited your father's judgment, did you get a call from home?
I was dictating the judgment at home.
Oh, okay. Did you feel that?
No. Unfortunately, by the time I decided, my parents were gone.
Yeah.
But I must, again tell you something which is very personal. So when I dictated that segment of the judgment, when I came to the conclusion that my father's judgment in Saumitri Vishnu was wrong, it was, late evening. And after I completed that dictation, that part of the dictation, I just told my secretary, I said, Chetan, enough for the day. Because at a certain level, I knew I was overruling my father's judgment. I had to do what I had to do as a judge. But having done it, I said, well, I'm going to take a break for the day. That was all.
So, your father's a judge, you're a judge, your sons are lawyers. What is this thing about judges and lawyers? Why does this happen? Why? I mean, of course, it happens in the medical fraternity too. But why were you under any kind of pressure that I have to get into the legal profession? Were your sons under any pressure to get into it?
Well, speaking for myself, after I did my Bachelor of Arts in Economics and Mathematics.
St. Stephen's.
Yeah, from St. Stephen's. I decided to pursue a post-graduation in economics because I topped Delhi University and I was fascinated with economics. And I thought I should, perhaps consider doing a postgraduation.
But before
in
that,
economics.
St. Columbus, you were what? Somebody was telling me, what pointer was it? You have these point system, right?
5-pointer.
5-pointer.
I actually got a 6.
6-pointer. You're the only 6-pointer or the
No,
first
we had a couple
6-pointer
of,
or something?
We had some other 6-pointers
Yeah.
as well, and you had 5-pointers as well.
Huh.
So I was not the
I think
smartest kid on the
Khan
block.
or somebody was also, but later, much later, of course.
So, I decided to go into the law school because the classes at the Delhi School of Economics were to begin later. And I joined the Campus Law Center saying that, well, I'll try and see what law is all about because, the law college began earlier. And having once entered the portals of the Campus Law Center, there was no going back. We had a fascinating set of professors. I was just fascinated with the law, and then there was no question of going back.
But when your sons decided to become lawyers, they don't practice here when you were here.
Yeah, actually, my
One son is abroad,
He's
right?
abroad.
Yeah.
He's a barrister in London. The other
Yeah.
one practices in Mumbai.
But will not come to Delhi when you are here.
Oh, absolutely. They both decided not to practice before the Supreme Court or for that matter in any court in Delhi so long as I was a judge of the Supreme Court.
But then it does happen, right?
And I did the same thing too.
You didn't, yeah.
I didn't come to a court. In fact, the reason why, to be very honest, why I decided to pursue a post-graduation in law after finishing my law degree from the Campus Law Center was because my father told me that, well, you will not practice so long as I'm Chief Justice of India.
So you went to Harvard.
And that's how I started applying to universities, honestly, overseas. And I got a scholarship.
Yeah.
My father told me that, well, I have my entire Provident Fund, which is yours, because there's no better cause I can spend it on than your education. But it so happened that I got a scholarship.
And you got a job, which was not in a legal firm there.
Yeah.
Why did you come back?
Actually, when I got a job, nobody from India generally got jobs in law firms over there. The Koreans got jobs, the Japanese got jobs, Chinese, people from lawyers from Europe, say Germany or the UK, they got jobs in US law firms. But when you said you're from India at the interviews, they'd say, India who? India where? So Indians generally didn't get a job because, we were still a closed economy. The market reforms which took place in the 1990s were still to take place. And they didn't think it worth their while to recruit Indian lawyers for the reason that what was the countervailing benefit that they'd get. So I still landed a job at a Wall Street firm. But I decided to come back for a variety of reasons, actually. To be very honest, I came back for my parents. You're young, and my parents were, my father was just due to retire. My sister was based in the US, and I just felt that, there had to be one of us siblings who would be close to our parents to look after them.
And now that you've retired, would you like to stay on in India or leave?
You know what's worse than a Monday commute to office? Making a resume. But my flatmate showed me this. Update your Naukri profile, choose a template, bas say tap and done. Genius. Naukri 360. Check it out on the Naukri app.
How
does that work?
Well, let's see what life brings for me.
Life brings for you. Okay.
It's sometimes, you always, think you do something and then you do something completely different because life throws up different
About
avenues.
family matters, I have to ask you this because there are many lawyers who say that हमको तो cases मिलता नहीं है. It's judges के बेटे, उनको मिल जाता है. And this entire system that is, of even selecting seniors. If you are somebody's son, somebody's daughter, that's how you get picked. What do you have to say that? It's not an unfair system.
Honestly, what you say does not lack the entirety of truth, but it has been my endeavor, both as a young judge of the High Court, later on as Chief Justice of the High Court, a judge of the Supreme Court and Chief Justice of India, to try and make the legal profession an equal opportunity profession. And you can do that in numerous ways. I'll just give you two examples. First, you spoke about designation of senior advocates. Between 1950, when the court was set up, the Supreme Court, and 2024, we had all of 13 women who were designated as senior counsel. This year in January, or February actually, we designated 12 women lawyers as senior counsel in one go. In August, when we did the second round, we designated, I think, 10 women lawyers as senior counsel. So we designated as many as, 12 plus 10, 22 women as senior counsel. None of them belong to legal families, or most of them didn't belong to legal families. Many of them were first-generation lawyers. And when we interviewed them, they told us their stories about where they came from. They came from small Tier 2 cities, Tier 3 cities, made their way to the Supreme Court, set up practice as first-generation lawyers. So I felt this is an enormous opportunity for us to change the way the profession is governed. I'll give you another example. All of us judges have judicial law clerks. And these judicial law clerks really assist us with research, but they are all young lawyers who've just passed out of law school. Now, the way the law clerks were typically recruited across the country was by word of mouth. And by word of mouth would often mean, a member of the bar saying, please take my son or take my daughter. And I said, this has to change. So I prepared a white paper during COVID. And it eventually gave rise to a policy which I adopted when I became Chief Justice of India. We have now been holding examinations at about 20 or 22 centers across India. So every young law student can appear for the exam irrespective of whether they are connected on networks for law clerks. Okay. And these are very highly prestigious positions because, of course, we pay them reasonably well. We pay them 80,000 rupees for the first year and 90,000 rupees for the second year, which is much more than what a normal lawyer would pay a young lawyer. But more than that, it gives you an opportunity to clerk with a judge. And so many of these law clerks then go abroad, they do their masters. My law clerks are all over the world now, and I take a great deal of pride in them. So what's happened is that as a result of our opening up our processes, it's ensured that people who are not connected with the law have an even chance of working with a judge. And working with a judge of the Supreme Court is an enormously prestigious thing for young. So these are things which you can do. So
two things which I have to discuss with you. One which you mentioned earlier, the collegium system, and two is pendency, which it'll be unfair that we're shooting in Delhi and we don't bring up the 84 riots and the long judicial process and still no justice. So that I'm going to come to. But before that, the collegium system where judges selecting judges, it's been criticized on the grounds that there is nepotism, it's an unfair process, and one of your quote when you said the collegium system is not perfect, but it's the best available. Why is it the best available?
Right. Now, first and foremost, the perception that in the collegium system, it's the judges who select judges is incorrect.
Okay.
The process of initiating the recommendations for appointments to the High Courts starts with the Chief Justice and the judges of the High Court, where they consult amongst each other and the judges of the High Court, and then they recommend people for appointment. But those recommendations are then vetted at various levels. For instance, the first level at which they are vetted is by the chief ministers and by the governors in the states. The files then move to the Government of India, where the files are then carefully reviewed by the Department of Justice. The Intelligence Bureau of the Government of India makes a very careful assessment of the credentials of the candidate, their antecedents, their character, their background. After that, once the inputs are put together by the Department of Justice, the file comes to the Collegium of the Supreme Court, where the consultee judges who have routed through that High Court are then consulted. So if it was a case for Bombay or Allahabad, two courts where I had worked before I entered the Collegium, my views as a consultee judge would be sought. It is after all this is done that the Supreme Court prepares its recommendations. So the process of appointment is a multi-layered process, particularly in a federal polity like India, where the actual appointment is processed at different levels in the system.
As compared to the American system, where it's completely political.
And in the American system, it is completely political, where the appointment of a judge of the Supreme Court comes up for confirmation before the Senate, and which is completely politicized. We don't work on that model.
Okay.
Also, we must understand that appointment to district judges, for instance, and which is the first level, the district judiciary, not district judges, but district judiciary, which is the first level of the system, is through a competitive examination process, which is conducted by the high courts or by the public service commissions in the states, as the case may be. As a result of that, almost 50 or sometimes 60% or more of the new recruits across India are now women who are entering the lowest levels of the judiciary, and they will obviously rise tomorrow and become high court judges, and some of them will come to the Supreme Court.
But if they don't have connections, will they get?
Absolutely. All these people who are appointed to the
examination system, I get, but as they get higher, don't they need to have their connections?
Not in the least. They wouldn't have that, because that's the point, that your progression through the ladder is primarily based on seniority.
Okay.
Subject to having a good record. So, a civil judge junior division will become a senior civil judge, then an additional district and sessions judge, a district judge, then a high court judge. And some of them, of course, can even come to the Supreme Court.
The pendency, crores of cases lying. What is the solution to this? More judges, more courts, what should be done? And do it quickly. I remember the first week when you came in and you spoke about this instance where you saw a woman who came to you and said, "Kuch kijiye, mere paas paise nahi hai." You spoke about this, and very evocatively, you said that you want this system to change where the poor have access to the judiciary. It's not just those who have resources, and quick judgments. Like, for example, in this one, he says it's a 40-year journey towards justice, the 1984 anti-Sikh riots, and nothing has been done. Victims are dead, dying, too old to care anymore. And, such a famous lawyer who says that the judiciary has failed to complete the process. All of us who have seen that as children, the 84 riots, just feel so helpless that kuch nahi hua uske liye.
What you say is there's a germ of truth in it. And what is the problem? What is the essence of the problem? First and foremost, the judge to population ratio in India is amongst the lowest in the world.
Yeah.
We do not have the number of judges which you require in the district judiciary to handle the kind of volume of caseload which is coming into the district judiciary. So first and foremost, you have to increase the judge to population ratio by appointing more judges.
Who will do that?
But appointing more judges is not just is just not a function of appointing more people, but having more qualified people who come in, which means that you have to identify more qualified people. Second, governments have to invest much more in infrastructure, which is not being done. Third, today, there are about 21% of the posts in the district judiciaries which are lying vacant. 27% is roughly the 27% is a vacancy in the staffing pattern of the district judiciary. Now, that is something in a federal polity which is handled by the high courts and by the public service commissions in certain states. Speaking for myself, I feel that one solution for the vacancies in the district judiciary is to have an all India judicial service examination, where the states would recruit, but there'll at least be one all India examination yearly, which will be held on schedule, and the people in that order of merit, and applying reservations, of course, as applicable to every state, would be selected by the states. So we have to find innovative solutions.
Have you recommended this?
This has been something which has been, but it will require constitutional amendment to my mind.
Okay.
Because, the recruitment and conditions of service of the judges to the district judiciary is controlled by the governors, and obviously in consultation with the...
Like you have police reforms, like you need admin reforms. If we are to become a developed nation, within a span of time. I don't want to put a number to the number of years, but if we are to do that, don't you feel that it's
absolutely.
imperative?
It's imperative that we begin, and we have to begin at the base of the pyramid. And we need these judicial reforms at the base of the pyramid.
Okay.
We first and foremost need to fill up all positions which are vacant. Second, and that's something which people don't know, a lot of the delays which occur in the administration of criminal justice is due to reasons for which the judiciary has no control. For instance, service of summons and securing the presence of witnesses of the accused is not a function of the courts. And a large number of criminal cases remain pending on the docket of courts because the accused are absconding or the witnesses don't appear on the day that the witnesses are supposed to appear. Now, this is not a function of the courts because to secure their presence is not the function of the judge.
Who's then?
It's obviously the summons are served by the police machinery.
So that's where there's a problem.
Now, a lot of pendency of cases is just because of the fact that the accused is absconding or that the witnesses don't show up. Now, there is still an answer to that.
Like in the 84 case.
Now, there is still an answer to it. And that's an area which I had worked on extensively because I was chairing the E-Committee, which is to employ technology for more efficient functioning of the criminal justice administration. For instance, video conferencing. It was because of the video conferencing facilities that we had that our courts didn't shut down during COVID times, as courts in many other parts of the world shut down. Now, we can apply video conferencing, which the new criminal laws do envisage, for recording evidence of witnesses. Say a person who has to, say an investigating officer who has to give evidence in a murder trial or in a rape trial.
Like in the Yasin Malik case also they said that it can come up.
A police officer who is transferred by the time that, the evidence has to be given and is transferred to another district, that police officer can give evidence through video conferencing. Or a medical witness, say somebody who was recorded a dying declaration of a woman who was, say, allegedly burned for dowry. That medical officer can give evidence through video conferencing instead of having to leave their hospital and to go from one end of, say, Uttar Pradesh or Madhya Pradesh or Rajasthan to another end of the state. So technology can be used in very radical ways to expedite the process. When evidence is recorded, when the witness deposes in a court, the deposition of the witness is transcribed by the judge. The judge will dictate what the witness has said and then that's taken down by a stenographer. That can be obviated simply by speech to text transcription. We have started that in the Supreme Court. In important constitutional cases, we have speech to text transcription of all the oral arguments. We have now a pilot module in place even for the e-courts project, which can be implemented in the district courts.
Hours can be saved per day.
Absolutely. So there is a lot that technology can bring in. Now, to give you another example, case categorization. You have cases which raise the same issue. Say land acquisition cases. There may be 2,000 cases relating to acquisition under the same notification. Case categorization has enabled us to identify which are those cases. Once we categorize those cases scientifically, those cases can then be taken up as a bunch of cases for decision making. Another important area which I'd like to share.
You can use AI in this, right?
Absolutely.
Yeah.
You can use AI not for actual decision making, but for the processual parts of our court work. Another area, for instance, where almost 50% of the time of a judge in our district judiciary is spent in roll calls of cases which will be adjourned because witnesses haven't shown up, because the service on the accused is not complete, or in a civil case, service on all the defendants is not complete. Why should these judges in the district judiciary across the spectrum be made to spend so much of time, fruitless, unproductive time, on these kind of procedural things which can be easily farmed out to non-judicial personnel to ensure that the case will actually come to the judge only when it is ripe for
judgment, instead of just
ripe for hearing, maybe the interlocutory hearing or the final hearing. So these structural reforms are extremely crucial if we have to have, in that sense, a modern judiciary.
Is somebody working on them? That's what I want
absolutely.
to know.
I'll just give you an example on technology. On technology, we have now started e-filing of cases. Case records are being digitized across India. This has been a radical change. We have a 7,000 crore phase 3 of the e-courts project, which is being implemented at present. We send if you'd be surprised by the number of emails or the number of text messages which we send, which is unprecedented in any part of the world, in India, to litigants. We have ensured that litigants now have knowledge of what exactly is happening in their cases. And this is the case information software which we have developed as a homegrown software in India. So tremendous amount of work has been done in terms of incorporating technology in the judicial process.
So one of the complaints about the Supreme Court is that wealthy people hire the best lawyers. I spoke about that case where you came in. And the poor people, they have legitimate grievances, but they're asked to approach the High Court first. Don't come to the Supreme Court. Like, go to the lower courts. Whereas if you have more resources, they come. You mentioned it too in one of your answers. What is the solution to this?
Well, you cannot ever prevent wealthy people from hiring good lawyers, right? That's a question of demand and supply and of resources. But to say that, wealthy people get a hearing first in the Supreme Court when poor people are asked to go first to the High Court or the District Court is wrong. Irrespective of who is applying, say for bail, the same principle applies.
It also came up during the Arnab Goswami case that there are under trials who are languishing for almost a decade or more, but Arnab got a hearing.
Arnab's case came in appeal to the Supreme Court.
In appeal, yes.
He didn't come to the Supreme Court as a matter of first recourse. He went to the High Court. He failed in the High Court and then came in appeal to the Supreme Court, which is a matter of right. So also Zubair, when he came to the Supreme Court. That's why I said A to Z. He came to the Supreme Court exercising his constitutional prerogative and the right which is available under Article 136 of the Constitution. But the answer to ensuring that poor people, less resourced people, also have qualified legal services is to strengthen the legal aid movement. We have the National Legal Services Authority, which is doing commendable work. The senior most judge of the Supreme Court heads the National Legal Services Authority, NALSA. Likewise, we have in the states the State Legal Services Authorities. And we have the legal services movement, which has gone down to the districts. Now, the challenge before us is to ensure that legal aid ensures quality legal aid. And quality legal aid is really the key, that even the most poor, particularly the under trials, who may not otherwise be aware of their rights, there are no takers for them, their families have sometimes distanced from them, they are entitled to the best quality of legal services.
Can there be, like, say, in the American system that, all cases don't necessarily need to come to the Supreme Court, that, certain cases you deal with at the lower courts and they're done with, like, say, divorce cases or whatever. You're done with the lower courts and that's where it ends. Is that a solution?
That could be a solution, but that's not the model our Constitution followed. Our Constitution created, and with a great sense of vision in when the Constitution was being drafted, an open access to justice model. So we have Article 136 of the Constitution, in terms of which an order which has been passed by any court or tribunal in the country can be the subject matter of a special leave petition. Now, if you restrict access to justice, that creates its own problems. Because then what would happen is, especially, the deflection from justice occurs the most in the case of those who don't afford good legal services. And if you were to follow that model, say, which has been followed in many of the Western countries, that would really, in that sense, detract from the cause of justice to the...
It's double-edged, right? Like, you want instant, or you want justice, but you don't want pendency. So, in both ways, I feel argument is strong.
I want to emphasize that, the Supreme Court is not a court for the resourced. It's not a court for the rich. It's a court which deals with the problems of the poor.
It ought not to be, or is not?
Is not.
You feel
is
that?
Not. It isn't. Because it's someone who has worked in the Supreme Court as a judge, as a lawyer, who will tell you that. Because, you have benches after benches of the Supreme Court dealing with bail applications of the smallest persons. In the last 2 years that I was a judge of the Supreme Court, 21,000 bail applications were filed. These were bail applications of common citizens. We disposed of 21,358 bail applications.
In your 2 years?
In my 2 years. Much more than what was filed. And those are bail applications involving small, many of them very, very ordinary citizens who have, cases of cheating, cases under the NDPS Act, cases involving, assault,
But there are
small
personal liberty
offences.
cases also. You've spoken about personal liberty a great deal.
Yes.
In that, could you tell me about those cases also which are pending, which many people feel that it comes up and then they don't get bail?
Well, I must tell you that, over the last 2 years, we followed this procedure. I ensured that every day of the week, every single judge deals with a certain number of transfer petitions. Those are typically matrimonial cases. And a certain number of bail petitions. So at least about 15 cases per day between transfer and bail petitions were heard by every bench of the Supreme Court. We prioritized cases involving bail and habeas corpus. That is why you have these figures where the actual disposal of bail applications was much more than what was filed. Now, whether bail should be granted in a particular case to an individual is a matter for that judge or that bench to decide. That bench may, on a scrutiny of the record, may feel it's a case for the grant of bail to protect personal liberty. A bench may feel that by granting bail, I would be detracting from the social interest, the interests of society in prosecuting for crime. If it's a heinous offence, a bench may well feel that I don't want to grant bail. Because that's a call for that bench to take.
हे आहे देशातील नंबर 1 न्यूज नेटवर्क आणि आपण पाहत आहात TV9 मराठी. काळजी तुमची, हित महाराष्ट्राचं.